At trial, if the judge gives unfavorable rulings, can we request a new judge during the course of your trial? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury lawyer practicing law here in the state of New York. The answer is it's going to be very difficult to do that. It's not like in the middle of trial we can say, "Excuse me, judge, I don't like your rulings. Can you please leave and get another judge to take your place, and now we can continue on our trial?" The answer is it's going to be really, really difficult to do for a number of reasons. If we don't believe that the judge is giving us a fair shake, and now objecting to every single thing that I'm trying to do, and we think that he's so biased and in favor of one side, now there are a couple things I have to do. Number one, I have to put all my observations and comments and objections on the record. And typically I'll have to do that when the jury is out of the courtroom. The second thing is that if I believe the judge is being totally unfair and is totally biased, then I'm going to have to approach the judge quietly out of the presence of the jury and say, "Your Honor, I don't think you're giving my client a fair shake, and because of that, I'm going to ask you to recuse yourself." Now that means that I'm asking the judge to excuse himself from that particular case and then bring in another judge to start this case all over again. The likelihood of that happening is extremely, extremely small. And now I have to have a really good reason why I'm asking the judge to recuse himself. But keep this in mind. When I do that, a number of things are going to happen. The judge is going to demand a very good reason for why I'm asking that. And number two, the judge is going to be very offended because if I don't have a good reason for doing that, he's going to get angry and now he's going to get defensive. And now, in all likelihood, he's going to say, "No, I am perfectly unbiased. I'm able to judge this case fairly." And really, his goal, the judge's goal, is to judge this case and make rulings of law and to give the law to the jury. So even though there are certain issues that come up and the judge continues to side with the other parties, the fact that I have now recorded my objections on the record, made my comments out of the presence of the jury, what that does is now it protects my rights, my client's rights, so that if we lose the case and now take the case up on appeal, the higher court can then look down on the record and see, okay, the judge did this, Mr. Oginski objected here, he stated his reason why. Let's see whether that was appropriate. So why do I share this quick tidbit of information with you? I share it with you because there may be an instance during the course of your trial where you think the judge is totally against you. Every single thing that comes down, he's ruling against you and in favor of the defense. And you think it's totally unfair, and now you want to get another judge to come in, take over his place. That won't happen very often. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.